Off we go. Good morning, everyone. Dave Kubikian here from the Herzog Law Firm. I'm one of the partners at Herzog Law Firm, and we do seminars often. And because of COVID, we do webinars even more often. And one of the silver linings of this ridiculously bad year has been that we've reached a lot more clients. We've gotten a lot more information out there because in the past it was hard to figure out what days and times are the right days and times and locations for people to travel in their car, go to a hotel conference room, and listen to our seminars. It's far easier to do it on your couch or look at them on demand as they all are now on demand. The topic today is a really big, important one. Wills versus trusts. And we don't hide anything in the name. We're going to talk about wills. We're going to talk about trusts. We're going to talk about what similarities they have, what differences they have, the pros and cons of each. They both, to a degree, accomplish similar goals, and then they stop accomplishing similar goals and go their own way. I ask you a couple things. Number one, you don't leave here thinking you need a will or you need a trust. I'd like you to leave here thinking, you know what, I need a little more information based on my fact pattern because Dave is just talking generically. And the devil's in the details. The specifics really do matter. I have people who come in who think they need a trust and they don't. I have people who think they just need a will and they need a little more than that. Life's a little more complicated for them. And hopefully this webinar will help you guys get some more information, again, about wills and trusts. So let's get going with our slides. So what's an estate plan? Good question. An estate plan is a way for people to get things when you pass away. Estate planning is a nice way of saying who gets your stuff when you're dead. Estate is something that only exists when you're no longer here, and obviously planning for that moment is what it's all about. Now, that being said, there are big portions of the estate plan that deal with your life a lot more than they deal with your death, but generically we all call it part of your estate plan. And it's for that reason that everyone 18 years or older really does need to have an estate plan. It's not because we're planning on an 18-year-old passing away or becoming incapacitated or being disabled. Of course, those are all possibilities, but we're also cognizant of the fact that at 18, we're an adult, and it's important to have documents during our life, like powers of attorney and healthcare proxies to help us during our lives. And those are all basic parts of the estate plan. In fact, your basic estate plan is a will, a power of attorney, and a healthcare proxy. And those healthcare proxies and powers of attorney, those things during your life, help us avoid things like guardianships one day if we become incapacitated, right? The idea is we pick a sunny day and we're planning for the rainy days. We're deciding who can speak for us, who can sign for us, who can transact for us in the event we are incapacitated. Your planning needs grow over time because life gets more complicated. And I hate to say it, every year we're here, right? In the future, we're probably here one less year, right? That's how it works. So the older we get, our plans change. The older we get, the more likely it is we have grandkids and we're more concerned with our legacy, right? The younger we are, basic wills can do the trick. As I mentioned, the basic plan, power of attorney, healthcare proxy, and a will. In terms of the power of attorney, it's for during our life, we're picking someone called an agent, and that agent's going to do whatever we tell them to do. In fact, their job description is to follow your instructions. It's on the very first page. If you're incapacitated, or if you're out of town, you're stuck in paradise and there's a storm coming in, the flight canceled, you just can't get to the bank. A power of attorney allows someone else, people of your choosing, to be able to transact for you. Again, it could be bad news, right? Dementia, and we can't we don't have capacity anymore. Or it could be something like, we're not feeling good. I just got my second COVID shot. I'm going to stay in bed today. Sweetheart, do you mind signing this for me? Which brings up a really important point because a lot of people think that their spouse can sign for them. Not true, okay? A lot of times people have joint bank accounts and I can sign a check, my wife can sign a check. That doesn't mean she could sign for me. It doesn't mean I can sign for her. So power of attorney becomes incredibly important now, and even more down the road when we're dealing with elder law and long-term care issues, because as we'll find out, there's a lot of tricks that people like me have in saving money and getting long-term care in the right situation for you. And a lot of times we need a power of attorney to be able to act for mom, a power of attorney to be able to act for spouse in order to make that plan come to fruition. In terms of a healthcare proxy, we combine healthcare proxy and living will into one document. They're two separate concepts. The general idea, though, is we're picking someone today who can speak for us when it comes to healthcare. In the case of the healthcare proxy, the prerequisite there is you're unable to make your own healthcare decisions. And in the case of a living will, it's for end-of-life decision-making, which is incredibly important and personal. And I think it's really important that all of you, at the very least, have powers of attorney, healthcare proxies, living wills, and eventually a last will and testament. Now, wills come in different shapes and sizes. Don't let the names fool you. We could have, 30-page simple wills. We can have very short bypass or pour over wills. And these different ideas of the type of will it is, the will itself doesn't say this is a simple will or this is a pour over will. It's the rules in the wills that'll dictate the kind of inside baseball, the kind of will you actually have. For the most part, people who do not have trusts as part of their estate plan will have a simple will. And for the most part, those who do have trusts as part of their estate plan will have something more like a pour over will, where everything that happens to be in their estate, if anything, pours into their trust, a bigger bucket. So we're going to talk about some of these concepts. I kind of just jumped in here. We're going to spend 5-6 slides talking about wills and something called probate. Now, I read this all the time. It makes me excited because so many people don't have an estate plan, but it also makes me a little concerned because so many people don't have an estate plan. And, vast majority of us have life insurance. Just about everyone has retirement. They name beneficiaries, death beneficiaries, but they think a will is too morbid. Meanwhile, they have life insurance, not because they're going to live forever, right? They have beneficiaries on their finances, not because they're going to live forever, but the will somehow ends up being something that they really don't want to think about. But it is so darn important. In a will, there are a couple important parties to remember. There's obviously people who are going to get things one day from the will. They're your beneficiaries. There's an executor. That's the person who's in charge of making sure whatever your will says happens. And there's this process called probate, where we go from something being a piece of paper to something actually being your will. And the way probate works, probate, though it's a Latin-based term, it's to prove, it's the proving of the will. It's the process where after somebody dies, which is one of the prerequisites to your will meaning anything, your will is meaningless until you die, and then the state of New York says, yes, this in fact is your last will and testament. That process is called probate. New York's going to assume that everything was wrong in your will. They're going to assume that you didn't have your mental capacity when you signed it. They're going to assume that there was nefarious things going on. They're going to assume there was no attorney involved. They're going to assume that you didn't have the right amount of witnesses. And the purpose of probate is to show to the surrogates court in the county that you resided in that, no, actually, we do have 2 witnesses. Actually, you did have your mental capacity when you signed this. You did know the natural objects of your bounty. You knew what society says about where you leave things. You knew it's not normal to leave everything to your caretaker who's been taking care of you for 2 weeks, right? So on and so forth. The process of probate is not to show that what you did was a good idea. It's to show that you mentally were okay when you made those decisions, okay? So it's all about your capacity to sign. It's all about having 2 disinterested witnesses, 2 people who are not getting anything from that will, being witnesses to say, yes, in fact, Dave Kubikian did have the requisite mental capacity when he signed that document. We don't want handwritten changes. Sometimes people, they get married, their last name changes. My daughter gets married one day, her last name's not going to be Kubikian. Maybe it will, who knows, right? But likely it won't be. I can't just cross that out. I can't say, well, now I have 2 grandkids and I'm going to write this and cross this out and do this. it can actually invalidate the provisions. It can invalidate the whole will, depending on where those handwritten changes are. So the purpose of probate is to make sure that everything was done the right way. And as part of it, we actually tell those people who would get more money if there wasn't a will, we actually say, hey, guess what? You are getting less in this thing. And if you want, you can fight this will. And if you succeed, you'll get more money. Kind of crazy. So if you die without a will, it's called dying intestate. No, the state of New York doesn't get your money. That's possible. That's possible if we have basically no family tree whatsoever. The laws of intestacy say where your money goes if you never got around to doing a will, or if your will was rejected for probate. Under the laws of intestacy in New York, there's a very common sense approach as to where all your money goes. It starts with if we have a spouse and no children, right? No kids, but we have a spouse, we have a wife, everything goes to our wife. If we have children and our spouse predeceased us, or if we're divorced, or we have life partners or what have you, everything goes to our children because there was no spouse. That top bullet point there says, well, what happens if we have a spouse and we have kids? Well, we're basically splitting things 50-50 with the exception of the first 50,000 going to our spouse. And then after that, if we die, we don't have children, we don't have spouse, we go up to our parents. Doesn't matter if our parents are doing well or not. We've had a number of occasions where our clients, long-term clients who are eventually getting long-term care and covered by the Medicaid program, we have them inheriting hundreds of thousands of dollars. It happens probably once a year. And it's a good fact pattern for me to convince people to plan, but it's an awful fact pattern in terms of that family. If parents aren't around, right, then we're going to siblings, nephews and nieces, great nephews and nieces. We don't have those. We actually go up grandparents, maternal, paternal, uncles and aunts, first cousins, and so on and so forth. Okay. So again, really barren tree for anyone to get anything. But the reason why this is important is because when we have a will and we pass away and we have to go through this probate process to prove the will, because there's assets we need to administer, the people who have the power to stop that or slow it down, the people who are interested parties to this proceeding are going to be the people who would get if there was no will, right? Because if they were to succeed in kicking out the will, we need to know who's an interested party. There might be prior wills that list other beneficiaries, so they may be interested parties because you know what, they would get more money if that old will was used instead of this new will. So a lot of times we talk about probate. It's a bad thing. It's a four-letter word. The reason why is because even when it's easy, even when everyone gets along, it's a long process, about a year at least. It's an expensive process. The high end of the filing fee for an estate in New York State is $1,250. That's the court fee. That's before someone like me gets involved. Okay, so a lot of good reasons to try to avoid probate. And the ways you can do so is, well, on the slide, look at that. So your will doesn't govern everything you own. Your will governs the things it governs. What do I mean? Well, I'm going to use myself as an example. This is probably my 300th seminar I've done in my life, and this is probably the 300th time I've died during a seminar. If I died right this second, okay, we don't need to look at my will to see where everything goes. Why not? Well, I have life insurance. My wife is my beneficiary. I have joint bank accounts with my wife. We own a house together, titled together. She's my beneficiary on retirement, right? So if I died right this second, right? Natural causes, of course, right? Everything, life insurance, retirement, house, bank accounts, all go to her. Snap of a finger, right? No probate, no rules. The will doesn't matter, right? There was no need for the will to go through this probate process. And that happens a lot of times when the first spouse passes away. I often say we get a free death, right? First of all, you got to have some weird sense of humor if you do what I do. The reality, though, is when we talk about probate, we're usually talking about that process for the second spouse to die. Why? Because at that point, we don't have another spouse on the house, right? We may not have as many beneficiaries on bank accounts and other assets. So we can avoid this whole process by having things that have beneficiaries or owning things that are jointly titled. Cool. That doesn't mean that that fixes everything, because even though probate is this four-letter word, probate can be really important. And now we're going to just go back to a situation like myself. Let's assume I wasn't an estate planning attorney that wrote his own trust. Okay. If I had a will, okay, well, let me go back one more step. I have life insurance. I have a wife. I also have two kids. My little guy is going to be 2 in May. My daughter is going to be 8 in July. I can't believe it. On my life insurance, my wife is my primary beneficiary. Who do you guys think is my backup beneficiary? Now, this is what I miss with the live seminars, right? I could ask you questions and you could throw answers at me. Now, you got to see how you can unmute yourself or go in the chat room. I'm not unmuting anyone, all right? Most people will yell out something like your kids, and I'll say, you're crazy. I just told you, one's about to be 2, one's about to turn 18 practically with my daughter. It's a really bad idea to name little kids as beneficiaries of things like life insurance. And the reason why is because they're little kids, right? They won't get the money at 2 years old and 8 years old, but they will get it at 18, because at 18 they are adults, right? We were all 18 one day. I don't know how many of us at that time were actually adults. I think I was an adult at 30 personally. Point being, I don't like the idea of lots of money going outright to kids. And sometimes it's really important to have rules on money. And you know what? Your will can have rules on money. Your will can say, upon my death, I give everything to my wife. Next paragraph, if my wife predeceases me, I give everything to my kids, or my issue, which is a term we often will use, which means our bloodline. So I leave everything to my issue, to my kids. Next paragraph, if any of my kids receive money and they're under the age of 30, hold it in trust as follows. Give them a little bit at 22, give them a little more at 25, give them the balance at 30. And you know what? Because of school, because maybe they need to buy an apartment, trustee or executor, really it ends up being a quote unquote trustee under a testamentary trust. We'll talk about that in a second. You can give money earlier. You could pay for school for my daughter, right? You could pay for law school, hopefully, for my daughter. Same will, different paragraph. You know what? If my son's a really immature 25-year-old, I don't want him getting 25% of anything. Just pay his bills for him and keep tabs on him. I could do anything I want within reason in a will, right? I could put rules on money. So while it's really good to avoid probate because it could be quite a difficult process down the road, I find it better to just not die for a while and avoid probate a different way by doing a trust. Now, for people my age, for friends of mine that have wills, right? Good, solid, simple will with provisions about guardians and provisions about when their kids could get money if their spouse predeceases, or if they're in a limo accident, God forbid, or these awful things that happen in life, right? It's all covered. And then what we say to those clients, what I say to my friends is, hey, listen, on your life insurance, you're going to have your wife, number one. Number two, let's put your estate. The estate of Dave Kubikian is the backup beneficiary on life insurance. Why? Because all that money funnels from the life insurance into the estate, governed by the will, and the will has all sorts of rules, pages and pages of rules as to how money should be dealt with for those little kids. So I want to be clear here. All things being equal, I want to avoid probate, but all things are never equal or rarely equal in my profession. They certainly could be. It's fact specific, case by case. And obviously, as later on in life, I really do want to avoid probate. And it's less of a concern about minors because it's later on in life. Certainly there might be grandkids that we're worried about, but it's more likely that we're going to go the next step of avoiding probate in the second half of this presentation, which is trusts. So what is a trust? What is a trust, guys? Well, a trust is a thing, I call it a box, that you can create where you can put rules on how money goes into the box and how money comes out of the box. There are two main kinds of trusts. First is called a testamentary trust. That's the trust I was just talking about, right? I have a will, everything to my spouse. If my spouse predeceases me, everything to my kids, okay? But I have these rules, right? Not until age 22, 25, 30, 40, whatever you want. Those rules, right? They are a trust. I'm creating a trust within my will. It's called a testamentary trust because it's in my last will and testament, right? So it makes sense. It's a trust that I hope never sees the light of day because I want my wife to survive me and I don't want both of us to pass until my kids are parents themselves, right? Maybe even grandparents themselves if I'm so lucky. So the goal is for that language to never matter, but because bad things happen and we don't know when it's going to happen, that language is really important. Most wills that we do have sometimes 2 or 3 testamentary trusts, depending on the lay of the land when it comes to kids and grandkids, special needs here, or we're worried about money here for this child and so on. Testamentary trust. The other main kind of trust is an inter vivos trust or a living trust, a trust that takes effect today during your life. Remember, with the testamentary trust, with all those rules for my kids, we don't get to those rules. We don't get to those words, okay, until what? Until we die and our will goes through probate, right? We need that to happen before we can then look at the testamentary trust. So it's going through probate, but at least we have trust language in our will. The inter vivos trusts, the living trusts we create today, right? And those take 2 main forms. Okay, there's revocable trusts and irrevocable trusts. Now, I'm going to make a big deal out of this. It's kind of my thing, okay? Words matter. I've written a lot about how words matter. And the word revocable and the word irrevocable have really huge consequences in my world. They mean things in your world, in the regular world, right? If I said to you, I'm irrevocably giving you my calculator, you wouldn't expect me to be able to grab my calculator back out of your hands because I irrevocably gave it to you, right? Oftentimes when I talk in seminars, I say, hey, what does the word irrevocable mean to you? And what do people yell out? They yell out, you can't control it. You can't undo it. You can't change it. And yeah, that may be how we use the word irrevocable day to day, but that's not actually what it means from a legal standpoint. And I will explain myself in detail here. So 2 main kinds of irrevocable trusts, revocable and irrevocable. There are different kinds of revocable trusts. There are different kinds of irrevocable trusts. And if I was going to have a sliding scale of revocable to really, really, really irrevocable over here, right? The trusts that we end up doing the most at the firm end up being barely irrevocable or revocable, right? These super duper irrevocable trusts, they're good for protecting against certain kinds of creditors. They're really good for saving money on estate taxes down the road. There's ways to use it as in conjunction with life insurance to create liquidity if we do have estate tax issues. There's lots of reasons to do super duper irrevocable trusts, but more and more we need special circumstances for the super duper irrevocable trusts. So we're going to talk about the barely irrevocable to the revocable. Because we're talking about barely irrevocable and revocable, the reality is they're mainly the same thing with a couple rather large exceptions symbolically, but in practice, not a lot of difference. Let's start with revocable. What revocable means, okay, the meaning of the word revocable means that you, the creator of the trust, of the revocable trust, you as the creator can take out everything from the trust whenever you feel like it. You could blow up the trust. You can revoke it whenever you feel like it with just your signature. That's what revocable means, okay? Now, the trust itself, this box, will have someone called a grantor or a settler. That's you, the person who creates the entity. It'll have a trustee. the person who's in charge of the trust or the signatory for the trust. That's what a trustee is, the authorized signatory of the trust. And then it'll have a couple sets of beneficiaries. First of all, during the trust, there's a beneficiary. And then at the end of the trust, at the end of the day, when we're dispersing things from the trust forever, right, there's going to be a beneficiary there as well. With revocable trust, typically, well, all the time, you are the grantor of the trust, and typically you are the trustee of the trust. Maybe you and your wife are your own trustees. And guess what? During your lives, during the existence of that phase of the trust, you're the income beneficiary as well. Now, you're not the beneficiary at the end of the day, right? In that regard, it's a lot like a will, because your trust will say exactly what happens one day when you're gone. A lot of times I refer to estate planning. I have lots of analogies in my book here. I refer to it as a car wash. And the reason why is because the plan as to where your assets go, how they go, when they go, all the rules on your money, that's a car wash. If you went to Hoffman's car wash tomorrow, right? And someone said, what would you like today? You have options as to what kind of car wash you want, right? You can get exterior only. You can get, a regular inside-outside wash. We can have all sorts of waxes involved. We can have Armor All on the tires, etc. Similarly, in estate planning, you could have different kinds of estate plans. And the number one goal of estate planning is to plan your estate, which means that whether you pick the general, easy peasy, exterior only car wash, a will, or we're getting into trust, revocable, or we get to some form of irrevocable trust, each one of those things will say where all your money goes one day when you pass away and all the rules on your money. The car wash is in each of these plans because when you go to the car wash, no matter what you pick, your car gets washed. Now, there might be bells and whistles we don't care about, so we don't do the super duper car wash, right? But at the basic level, who gets your things? That's ground zero. That's the starting point for me. So beneficiaries at the end of the trust, that's just like beneficiaries of a will, just like beneficiaries of a irrevocable trust. Now, you might become incapacitated one day, right? It's a living trust. This is for during your life. So there are things that can happen before you pass away where you will be replaced as trustees. So we pick successor trustees in our trusts for you. Upon your death, it's kind of a moment in time where whoever your beneficiaries were, wherever we're going to get things, they kind of get locked into stone, because up until that moment, you could amend your trust as you see fit to change who your beneficiaries are. Revocable trusts are great for avoiding probate and not much else. I mean, they're good for when we have complicated family trees, second marriages, children from prior relationships, where we kind of want to treat everyone the same, or we want lots more rules in our documents. We want some guarantees that when we have a second relationship, I can't just leave everything to my wife, right? My second wife. Don't tell my wife about my second wife. But if I left everything to my second wife, right? How do I know that if I died first, she's going to take care of my kids from my first marriage, right? I don't have that guarantee. So a lot of times we use revocable trusts to create that guarantee with rules and words on paper and so on. I won't get into it too much. But revocable trusts, they play an important role. By far, the more frequent trust we do is a different kind of trust called a Medicaid asset protection trust. It's a form of irrevocable trust, but in my scale of revocable to irrevocable, it's like barely right here. It's like barely irrevocable. Okay. So what's the deal with this trust, this Medicaid asset protection trust? And why is it called irrevocable? And why don't I think that's a big deal? Well, it's called a Medicaid asset protection trust because the rules of the trust make it so it'll be easier to protect your assets when it comes to your long-term care needs. How does it do that? Well, I'm glad you asked. It's important to realize how Medicaid works. So let's say we get older one day, that's the plan, and we keep getting older, and eventually we're 70, 75, 80, 85, 90, now we're 90. And we're not doing so hot, right? All those years of playing sports and skiing, and our knees are shot, maybe our brain is shot, we have dementia or this or that. we're going to have long-term care needs that we're going to need to deal with. And the rub when it comes to long-term care is that it occurs when you're no longer working. It occurs when you have a fixed budget based on your Social Security, your pensions, and your distributions from your retirement, and so on. So when we get to the point that we have long-term care needs, we don't have a lot of money. We don't have a lot of income. So we end up having no choice but to spend on our needs, and they're expensive, by using our assets, by spending down our assets, which in turn means that one day when we pass away, there's less to give to the next generation or the grandkids and so on. Medicaid has a program that pays for long-term care. There's a home care component, there's a nursing home care component. Let's talk about the nursing home because the rules there are the most strict. Let's plan for the most strict. There's a 5-year look back period where we need to plan ahead of time in order for the Medicaid program to allow us to protect our assets. They created this 5-year look back period to make it so you could plan ahead of time. If they didn't want anyone to plan, if they didn't want me to have a job, they'd say there is an unlimited look back period, but they didn't, right? They made it 5 years. And what they look at in terms of your assets are those things that you own, where you or you own or you have access to, where you, with just your signature, can grab it. Okay, that's what they care about. And when we talked about the revocable trust, right, the reality is one of the nice things, what revocable means is you by yourself can grab things out of your revocable trust. That's why it's revocable. So revocable trusts don't help with long-term care planning when it comes to protecting assets because it doesn't protect assets. Based on Medicaid's rules, the things in the revocable trust are yours just like they were in your bank account in your own name. Okay. So what happens? Well, attorneys far smarter than I, long before I was practicing, came up with this idea of a trust geared towards Medicaid's rules. And this trust is technically irrevocable. Again, I'm going to tell you what that means in a second. But the reason why it works is because we make it so you by yourself can't get your money like a revocable. You plus other people together can get to money, right? The goals are to live life, enjoy life, not be scared about a nursing home, not be scared about long-term care. And thankfully, there's a way for us to prepare for those needs while still being able to use and enjoy our money. And it's this specific trust, okay? So let's get back to this word irrevocable. That means all these, or has these bad connotations to it. I'm going to explain to you in the clearest definition ever what the word irrevocable means. You are going to sit there and you're going to say, son of a gun, that is the clearest definition of irrevocable. You ready for it? Irrevocable means not revocable. There. What do you think of that? So, of course, tongue in cheek here, literally irrevocable is not revocable. That's what the parts of that word mean, not revocable. And it's not a joke because revocable means you by yourself can pull all your money out of the trust. Irrevocable means not that, not revocable, not that. It doesn't mean we can't take money out of the trust, right? It doesn't mean we can't enjoy the trust. It doesn't mean anything other than when I want to pull my money out of the trust and put it back in my pocket, that one time when I'm doing that, I cannot do it by myself. I need third parties. And those third parties could be my children, and it could be my brother, and it could be my it could be my nephews and nieces. It could be whoever you want it to be. But factually, you by yourself can't pull your own money out of the trust and put it back in your pocket when you want to. But factually, you can pull your money out when you want to. It's just you plus at least one other person. And to kind of emphasize this a little bit, there's one word that is not in the Medicaid trust we do. Okay. And this stumps people all the time. The one word not in our Medicaid trust is the word Medicaid. It's not in our trust. I've looked. I did the spell, the word hunter and all that stuff. It's not in there. And it doesn't need to be, guys, because it's the rules that make something a irrevocable trust. It's the rules that make it a Medicaid asset protection trust. Here, we have a party, we're talking to an audience of one. We're talking to that Medicaid reviewer. We're saying, Medicaid reviewer, Everything that's been in this trust, I've used and enjoyed my whole life. My house is in this trust, my rental property is in this trust. I still get those rents. I put some stocks in that trust. I still get my dividends. I want to move one day. I decide where I move. I decide if the trust is going to sell my house. Nothing happens without me. I am the boss. I am the puppeteer, and I'm choosing who my puppets are. I'm choosing the show. It's all you. When I'm removing money from the trust, that one time I'm involving someone else. You know what? When you want to put on a puppet show, we need some puppets. And so your trustee, who cannot be you, ends up being the puppet, your puppet. So this irrevocable trust, this form of irrevocable trust called a Medicaid Asset Protection Trust, you are not the trustee. Your kids could be, anyone can be, other than yourself and your spouse. You are the income beneficiary of the trust, same as revocable. You could put your house in the trust, still get the star exemptions. You could switch your house with, you could sell it and then buy a smaller house. You could interchange assets of the trust, just like revocable. Okay. You can change your trustee. You could amend your trust whenever you feel like it with just your signature to change who your trustee is. We're not beholden to anyone. You know what? One of your kids is on your you know what list, and we've changed our mind as to what everyone's getting. You have the right to do that whenever you feel like it. No one else is involved in it, just like revocable, right? It's all just like revocable, except for when it comes to the one thing that matters to Medicaid, which is pulling money out of the trust. There, it's not just yourself, it's you and the people you control, right? Essentially, Medicaid says, can you do a puppet show by yourself? And the answer is no. I need puppets to do the puppet show. You always choose who the puppets are. You still control things in that way. But yes, technically it's irrevocable. Why? Because it's not revocable. I hope that's clear to you guys. It's a terribly important part of what I do, and hopefully it's crystal clear. If you need more guidance on it, let me know. Now, we're doing this for a reason, right? We're going to use and enjoy our money. We're going to avoid probate, right? Just like a car wash, remember when you do the super deluxe car wash, and I'd call this a deluxe car wash, it still has all the benefits of the lesser car washes. This Medicaid trust is no different. So we're avoiding probate. But while we're avoiding probate, we're protecting assets. We're going to shift our attention to home care if we do develop long-term care needs and we haven't gone through the 5 years, or we just feel like being at home, which is what most people want to do. Excuse me. Okay. So a couple differences in side-by-side analysis. And I got to reiterate, there is no right or wrong answer on this. These are options that you have, and we are pro-plan. At Herzog Law Firm, we're pro-plan. Whatever your plan is, we're all for it. Sounds good. We'll poke holes in it. We'll make sure you understand the pros and the cons of it. Wills. Wills are not as expensive as trusts. That's important. Wills go through probate. They don't mean anything. They don't govern everything unless we make things point to the will, like that life insurance for my kids I was mentioning. The process of probate can cost several $1,000s. You will not be here for that process, right, by definition, but it is a process you might want to make easier for whoever is left. It takes effect after death. It has no ramifications as to your current incapacity. We still need powers of attorney and healthcare proxies when it comes to managing your finances. Probate is a public process. It goes through the surrogates courts. I could look up anyone else's estate if I wanted to by going to the court. And by definition, it's inviting people who are not receiving as much in the will an opportunity to contest that will. Now, in movies, that's a big deal. In TV shows, oh my God, a will contest. It doesn't happen nearly as often as you would think. The next time I read a will in out to the number of beneficiaries in a conference room will be the first time I've ever done that. That doesn't, I don't think anyone does that anymore, maybe in other states. On the trust side, whether it's revocable or irrevocable, we can avoid probate, no probate, right? You can control your assets as you always did, but it's in terms of this separate entity, which means we're avoiding probate. It also means that if we're incapacitated, someone steps up immediately to be our backup trustee. Again, revocable, that's the case. Irrevocable, you're never the trustee. Okay, your affairs are private. It's harder to contest. I mean, you'd have to show that someone was really out of whack when they signed. There was fraud when you created that trust. And increasingly, that's harder and harder to do. And it's obviously not an open opportunity as part of the process. Okay. What's right for you? I don't know. I don't even know if I know you guys. I think I saw a couple of clients on the list, and thank you for coming to get your information. That's what consultations are for, guys. Whether it's with someone from Herzog, someone from another firm, it doesn't matter. Go to someone that does estate planning and elder law. You basically give them everything they want to hear in terms of assets. Tell them what's on your mind. Tell them what your concerns are. Tell them how you feel about your daughter-in-law. It's important, right? It's important to come up with a plan that fits exactly what you want. Okay. There are a couple times where I will often recommend a trust if someone wants a recommendation from me. In general, I hate probate. I'm willing to go through probate, and I've told my friends, my close friends, do a basic will. You don't have to spend money on a revocable trust. Why? Because they're young. And I say, just don't die until it's time to do the Medicaid trust and we're golden, right? Worst case, we go through probate, at least the car gets washed, right? At least no matter what happens, we have a plan as to where the money goes for those young kids. When we have real estate, it increases the likelihood that we're going to have some sort of probate because real estate doesn't have beneficiaries like your life insurance does. When we have property in multiple states, now we're talking about a probate in New York and something called an ancillary probate in Florida. Yikes. Now we're really spending some money. When we have complicated business assets, when we're really worried about creditors, whether it's Medicaid or lawsuits, we may want a kind of trust. Okay. When we're really worried about a will contest because we know we're not treating all the kids the same and so on. Again, avoid the public probate process if you can. We do free consults. Usually it's a 1 full hour. We send you a questionnaire beforehand, and it's, I know firms that do a half hour. I can't understand you and what makes you tick, and you can't get comfortable with me in 20 minutes. I don't know how they do that. But we do an hour consult. We do them now on Zoom. We do them now on the phone. We do them in person. We have a number of people at the firm that have been fully vaccinated just so that we can continue to serve some of our clientele that has some pre-existing conditions. We are on the radio every Saturday morning. It's replayed on Sundays. You can listen to us 8 to 9 a.m. on Magic 590, 100.5. A little further north on 1410 a.m. and 96.9 FM. Sundays we're down at WBPM down in the Kingston market. Great way to get more information. You're obviously here, which means that some information, some of this is really good for you. I salute you and recommend you continue to get information. That's what we do. Look at some of our other webinars. Look at our schedule for future webinars. Look at our catalog of old videos. We can send you slides from anything you want. And I really thank you guys for joining. I did see a couple things come up in the chat. Let's take a look. Will we email the video? Yes, we will. Can you simply define probate and what's the difference between probate and surrogate court? Well, probate court and surrogate court is the same thing. Okay, probate is technically the proving of the will, and surrogates courts do more than just probate. They may do certain kinds of guardianships. They can handle other kinds of matters. Sometimes they'll do guardianships, even though it's a Supreme Court matter. Sometimes people die without a will. That still goes through surrogates court. We generically call it probate, but technically that's not a probate. It's an estate administration, kind of like we call Band-Aids, but really Band-Aid is just a Johnson & Johnson adhesive bandage called a Band-Aid. That's what kind of probate is. It's a specific thing, but generically we call it probate whenever we have to go to surrogates court when someone passes away. Thanks so much, guys. I really appreciate you guys joining us. I'm going to stop recording this thing. I welcome all your questions through email. Call us for a free consultation. And again, thanks so much for joining us. Take care.